Welcome to G Fun Facts Online. We've all heard the saying, justice delayed is justice denied. For millions of people around the world, this isn't just a phrase, it's a crushing reality. Court systems are drowning in a sea of unresolved cases, a crisis known as judicial backlog. Some cases are delayed for months, others for years, and in the most extreme situations, for decades. This crisis, made even worse by the global pandemic, isn't just an administrative headache, it has severe consequences. It weakens the social contract, erodes public trust in our legal institutions, and places an unimaginable mental health burden on victims, witnesses, and even defendants who are left in a state of prolonged uncertainty. These delays also cripple economic growth, as businesses can't enforce contracts and investors are scared away by the legal instability. The causes are complex, ranging from a shortage of judges and staff to outdated procedures and simply an overwhelming volume of new cases. For years, the only solution anyone talked about was hiring more judges. But that's like trying to empty an ocean with a bucket. Today, we're going to explore a wave of incredible innovations that are proving there's a smarter way. From cutting-edge technology to fundamental shifts in how courts manage their time, we're witnessing a revolution aimed at taming the docket and ensuring that justice is not only fair but also fast. Let's start with the most exciting frontier, the technological revolution happening inside the courtroom. In our digital world, technology is offering a powerful beacon of hope. At the forefront of this transformation is artificial intelligence. Now, when you hear AI in the courtroom, you might picture a robot judge in a black robe, banging a digital gavel. The reality is far more practical and, honestly, more interesting. AI isn't here to replace human judges. It's here to augment them, to give them superpowers by handling the most time-consuming, data-heavy tasks. One of the biggest drains on court time is legal research and document review. Imagine a single complex case that involves tens of thousands of documents. It could take a team of lawyers, weeks or months to sift through everything. I can do it in a fraction of that time. A landmark case at London's famous Old Bailey Court provides a perfect example. I was used to analyze over 10,000 documents. This allowed a 20-person legal team to quickly pinpoint the most crucial evidence and prepare for cross-examination with incredible efficiency. Beyond just finding documents, AI can also perform case summarization. It can read through voluminous case files and generate concise summaries that highlight the essential facts, legal precedents, and key arguments. This frees up judges and lawyers from the drudgery of wading through paper mountains, allowing them to focus their brainpower on the core legal issues and strategic thinking. Another game changer is transcription. AI-powered tools can now accurately record and transcribe everything said in a courtroom, during a briefing, or in a virtual meeting, all in real time. This eliminates the huge administrative burden of manual transcription and creates a highly detailed, searchable digital record of every proceeding. Perhaps the most forward-looking application is predictive analysis. By analyzing huge sets of historical case data, AI algorithms can start to predict case timelines with surprising accuracy. This helps courts manage their workloads proactively. They can see where future bottlenecks are likely to form and allocate resources to prevent them before they even happen. The goal of all this tech is to let legal professionals do what they do best: apply human judgment, empathy, and critical thinking to the unique circumstances of each case. Technology handles the repetitive work, and humans handle the justice. Supporting this AI revolution is another crucial piece of tech, the Integrated Case Management System, or CMS. If you've ever seen a movie with lawyers hauling carts piled high with paper files, you understand the problem a CMS is designed to solve. A modern CMS is the digital backbone of an efficient court. It's a central, secure hub for all case-related information, accessible to judges, clerks, and attorneys from anywhere. The most immediate benefit is the massive reduction in paper. By digitizing records, courts can dramatically cut down on the delays and errors that come with shuffling, storing, and searching for physical documents. A robust CMS also provides the foundation for e-filing systems, which allow lawyers and even citizens to submit documents to the court online 24/7. This makes the entire process faster and more accessible. But the benefits go deeper. These systems are incredible data collection tools. For the first time, courts can get a clear, data-driven picture of their own caseloads. They can identify trends, understand the root causes of delays, and, most importantly, measure whether their reforms are actually working. This data also enhances transparency. By providing public access to dockets and case information online, a good CMS can build public trust in the judicial process. Many courts are now moving to cloud-based solutions, which are more scalable, flexible, and cost-effective than old, clunky, on-premises servers. The final piece of the tech puzzle was supercharged by the pandemic, the virtual courtroom. What started as a public health necessity has proven to be a game-changer for efficiency. Remote hearings, conducted over video conferencing platforms, eliminate the time, cost, and logistical headaches of physical court appearances. Think about it. For a simple 15-minute pretrial hearing, a lawyer might have previously spent half a day traveling to and from the courthouse and waiting for their turn. With a virtual hearing, it's just 15 minutes. This has been revolutionary for reducing backlogs, especially for non-complex matters, routine check-ins, and case management conferences. While virtual hearings won't replace all in-person proceedings, especially for complex trials, their successful integration points toward a more flexible, digital-centric future for justice. But technology alone isn't a magic bullet. Some of the most profound innovations have nothing to do with computers and everything to do with working smarter, not just harder. This brings us to procedural and managerial reforms. One of the most groundbreaking findings in this area came from a study focused on the Supreme Court of India. Researchers looking at its massive backlog discovered a surprisingly simple yet powerful solution. They found that judges were spending an excessive amount of their time on the early stages of cases, which created a huge bottleneck for cases in the later, more complex stages. The proposed solution was counterintuitive. Shift more judicial attention away from the early stages and onto those later stage cases. The projected results were staggering. By strategically reallocating how judges divide their time, the study calculated that the average case resolution time could be slashed from 275 days down to just 96 days. That's a potential 65% reduction in delays without hiring a single new judge. This principle of strategic time management is part of a broader set of smart reforms. One key strategy is called case triage. Just like in a hospital emergency room, cases are sorted by their severity, or in this case, complexity, right when they are filed. Simpler cases can be put on a fast track for expedited resolution. More complex litigation is identified early and given more intensive judicial management from the very beginning. This tailored approach stops simple disputes from languishing in the system and ensures that the most difficult cases get the attention they need to move forward efficiently. It's also about prioritizing effectively. An efficient court has a clear system for deciding which cases to hear first. This often means focusing on the oldest, longest pending cases to clear the historical backlog, or giving priority to cases where a defendant is in custody, or those involving vulnerable people. Another key procedural reform is embracing alternative dispute resolution, or ADR. The truth is, not every dispute needs to be settled with a full, formal trial. ADR methods like mediation and arbitration offer a less adversarial, faster, and often cheaper way to resolve conflicts. In mediation, a neutral third party helps the two sides reach a voluntary agreement. In arbitration, a neutral third party hears both sides and makes a binding decision. By encouraging and properly funding these alternatives, courts can divert a significant number of cases away from the trial track. This reserves precious and expensive court time for the most intractable and complex cases that truly require a judge's ruling. This process is strengthened when courts also have clear procedures to promote early resolution, identifying moments where a settlement is likely and intervening to help facilitate it before more time and money is spent preparing for a trial that may never happen. Underpinning all these reforms is a simple but powerful idea: collaboration and data. Tackling a problem as big as judicial backlogs isn't a job for the judiciary alone. It requires a multi-stakeholder approach. Structured collaboration between judges, lawyers, court staff, government agencies, and other partners is essential for identifying problems and implementing solutions that actually work. This collaborative effort helps to clarify roles, improve communication, and build partnerships that strengthen the entire justice system. And as we mentioned with case management systems, data is king. The old business mantra, "What gets measured gets managed," is profoundly true for courts. By implementing standardized ways to measure case progress, courts can monitor their performance, pinpoint the exact causes of delays, and scientifically assess the impact of new initiatives. Evidence-based policy is the key to making sustainable long-term improvements. Finally, as we race towards this high-tech, hyper-efficient future, it's vital that we don't lose sight of the human element of justice. The goal is efficiency, but the purpose is justice, and justice requires a human face. These innovations must complement, not replace, the experience, judgment, and empathy that legal professionals bring to their work. We must uphold the principles of procedural fairness. This is the idea that when people feel they have been treated with fairness, dignity, and respect by the court system, they are far more likely to see the outcome as legitimate, even if it's not in their favor. This builds long-term trust and encourages compliance with the law. In practice, this means court staff and judges demonstrating patience and empathy, especially towards people who are navigating the system for the first time and may be experiencing intense anxiety and stress. It also means being mindful of the digital divide. While technology can improve access for many, it can also create new barriers for those who are elderly, low income, or lack digital literacy. Courts must ensure that technological solutions don't inadvertently shut people out of the justice system. The road ahead is challenging, but the future is bright. The challenge of judicial backlogs is significant, but it's not insurmountable. The incredible array of innovations being pioneered around the globe shows a collective will to create a more efficient, accessible, and ultimately more just legal system. The future of justice will be a hybrid model, blending the best of human expertise with the analytical power of technology. It will be a system where courts are not just places of punishment, but also of help and resolution. A system that reserves full trials for the cases that truly need them, and one that uses data to constantly learn and improve. By embracing these innovations, judicial systems can move beyond just managing a crisis. They can build a new foundation for the administration of justice, one that is resilient, efficient, and capable of delivering on its most fundamental promise: timely justice for all.